All for coming here this bright and early morning to partake in the CLE that we have on ethics. The topic of the day is litigation bullying. Before I get started, I was told that there was one lucky winner of one of the raffles last night, a Mary Lou Hazelwood, and we've got a gift for you here. So if Mary Lou Hazelwood is around or anyone knows her, perhaps they can talk with this gentleman here and pick up her gift from last night. I'm not sure what it is, but maybe it's an iPad or something cool like that. But in any event, we're going to get started with our CLE on ethics this morning. We are pleased to have Sims Weimuller here from Schrader, Goldmark, and Binder. He practices in the area of medical negligence and products liability. Sims is a former chair committee of the professionalism for the Washington State Bar Association. He's a frequent lecturer on the topic of ethics, and today we're going to be talking about litigation bullying and you know, how it happens and what it is. And I'm pleased to introduce Sims Weimuller.
Thanks, everybody. I'm told there is a gold medal soccer match for the U.S. Team in the Olympics right now. So. Oh, is it basketball? Oh, I thought it was soccer. All right, good. Well, in any event, I appreciate you guys coming in light of that. And it being 8 a.m. and it being ethics and it being the last morning of the convention. So it's good to see you all here. Litigation bullies is the topic. It's going to be a how-to seminar sponsored by Allstate and Philip Morris. Instead, no, I brought the rule book and we're going to get RPC credit for this. We have 2 hours today. We have a great panel of folks. We're going to do a half an hour for my piece, and then we're going to have a sort of panel response and hopefully discussion and questions from you all. Then after that, Lori Haskell is going to do a half an hour or so. We'll have another panel discussion after that. So that's going to be the structure for the day, about 2 hours. We have a questionnaire that we circulated here this morning. So if you can take a moment to fill that out at some point, I think we're going to sort of collect it at halftime. I know that's the best way to pull everyone's attention away from what I'm talking about right now, but when you have a moment, just look it over and fill that out. We're just curious about your take on some of the topics we're going to be discussing today. So take a second and do that, please, if you would. I think that's it in terms of housekeeping. So today's topic, litigation bullying, is about fighting the good, clean fight. And you know, we deal with a lot of these issues. There's a lot of things to talk about. These are some of the things that I'm going to touch on. Try and come up with a rough definition of bullying. Look at some of the specific RPCs that I think will help arm you in dealing with bullies. And then throughout the course of the day, we're going to have a focus on diversity and cultural competency issues. So I wanted to lay out some of those elements. And then specifically bullying threats. Threats are a big part of bullying we see in litigation. And then a few of my tips at the end about what to do with a bully. So defining bullying, it reminds us of pornography. We know it when we see it. So I thought I'd start the morning out with a video of one of my favorite bullies from popular culture. I don't know if you have seen the film A Christmas Story, but I give you one of my favorite
The thing. It just cut in your skull. You sure weren't balling. I never booed. Baloney.
Scott Farkas. What a rotten name. We were trapped. There he stood between us and the alley. Scott Farkas staring out at us with his yellow eyes. He had yellow eyes, so help me God, yellow eyes. Ah!
right, so there's Scott, my favorite bully. I started off with Scott because people asked me when I said I was doing a CLE on bullying whether we're talking about dealing with bullies or whether trying to stop people in our organization from bullying, and it's a little bit of both. I'm going to encourage you throughout this 2-hour session today to be a little bit introspective and think about how you may or may not bully opposing counsel, younger counsel, your own clients, but also hopefully to arm you, and I think that we all encounter this at all stages of our careers, arm you with some strategies and also some specific sort of more tactical RPCs that'll help you deal with bullies as you encounter them. In defining bullying, it's a bit of a challenge to do it, and I thought we could steal from the school environment. RCW 28A has a definition, and there's a couple different elements. One, if there's physical harm, that's pretty obvious. Next, interfering with a student's education, I guess here I'd say a litigant. Severe, persistent, pervasive actions that create or intimidate or threat. And in persistent and pervasive is a sort of key element of bullying that we'll talk about today. And then disrupting the orderly operation of a school. There's several bullying programs out there, and they're mostly in the context of school bullying, but a lot of analogies apply. One prevention program says that there's 3 reasons that people bully. Power and dominance, that they enjoy suffering or watching suffering and injuring people, and that there's a reward in some way at the end of the day. And it made me think of one person in particular in popular culture right now. Sorry, I just couldn't resist. My apologies to any Republicans out there. But who knows if it's actually true that he is a bully or not. Hopefully we don't find out. So a few specific RPCs in bullying. The old RPC preamble used to say that we should zealously advocate on behalf of our clients. And we've probably all heard that. We probably all think that that's what we should do. And in many ways it is. But after in the Washington state, anyhow, after a 2003 Ethics Commission and then 2006 revisions, they realized that people were using this word zeal and zealously to cover any manner of litigation sins, that we could justify any actions on the basis that, well, it was in the best interest of the client and I was just zealously advocating on behalf of my client. And so I thought it was important that a few years later the new RPC preamble changed the language to conscientiously and ardently. We should conscientiously and ardently advocate on behalf of our clients. Frankly, I'm not exactly sure what that means as opposed to zealously. I can understand the former much more than the latter, but to me the important piece is the change that we were seeing. The Supreme Court and the Washington Supreme Court and the Board of Governors was seeing so much activity in the form of bullying, et cetera, that they decided to change the language that has been there for ages. And I think the idea is to try and inspire our better nature rather than our more base nature. I think what they ultimately saw was good quality professionals acting out inappropriately. They also made a change to RPC 1.3, and this is the diligence RPC, and people were justifying the use of the RPC to say, well, you know, I was pestering because I was just being diligent, and the new language says you can't justify offensive tactics. You know, you can't go from this guy to this guy just in the name of zeal and diligence. RPC 4.1, any misrepresentations of fact. This is the communications issue, and there's a couple more we'll touch on, but misrepresentations of fact in the process of bullying are a violation of the RPCs. So I raised this because a lot of times bullying comes down to personal attacks on you, on your client. So keep in mind some of these RPCs, especially when you know you're dealing with challenging counsel. You know, I like to have a list and keep them at the forefront of my mind, because as we'll talk about later, and I think the panel will agree that it's, you know, our responsibility to maintain our composure and respond coolly to bullying situations. And if you've thought through some of these issues ahead of time, you're going to be equipped to do that. Just to make that make sense, misrepresentations of fact prohibited under 4.1. Likewise, another one to have in your hip pocket, RPC 8.4D. This is sort of the general catch-all. Anything that's prejudicial to the administration of justice is also prohibited. So that's opposing counsel bullying you or your clients. Now I want to switch gears a little bit. I love this. If you can't read at the bottom, it says procrastination. I'll find a picture for it later. So procrastination in and of itself is not bullying, I don't think, but its corollary, intentional foot dragging, is. And I think that this is bullying that we as trial lawyers experience all the time from our corporate defendants. You know, the big insurance companies, big corporations that we go up against have the money, the power, the time, the documents, attorneys that have been working on these cases for decades. And when they aren't producing the documents or other discovery that you've requested time after time after time, it's passive bullying. And I think we should call them on it. And we should use some of the RPCs that I've talked about as a means to do it. RPC 3.2 is another one. A lawyer shall make reasonable efforts to expedite litigation consistent with the interests of the client. So foot dragging, intentional foot dragging, is in clear violation of this RPC. Likewise, there's a great comment to it. If this kind of delay is done for the purpose of frustrating an opposing party's attempt to obtain rightful redress or repose, it's prohibited. So again, keep in mind these RPCs. You can use them at depositions, you can use them in briefs, but I'd like to see our organization and trial lawyers using these more and more as a means of getting at these, I think, inappropriate discovery tactics from our opponents. One of their tactics is to dump huge amounts of discovery on you, and likewise, that can be prohibited under the rules. So use some of these RPCs. Now I'm going to switch gears and look at our role with our clients, and this is sometimes where things get a little uncomfortable, right? Do you bully your clients inadvertently or intentionally? RPC 1.2a, I think most of us are familiar with. A lawyer shall abide by a client's decision whether to settle a matter, right? It's a client's decision whether to settle a matter. But easy enough to say, you know, a little more challenging in practice. You've got a lot of money in the case. You've got a lot of time in the case. You think it's a good value. The client's not there yet. Are you advising? Are you encouraging? Or are you bullying them into a settlement? It's a case-by-case thing, and I'm not going to sit here in judgment. I know I've struggled with it as well. I just encourage you to remember your duties and be really, really careful about some of these issues. RPC 1.4 is the RPC on communication. I'd like to think of RPC 1.4 as the lawyer's informed consent rule, right? We have to bring our clients to an understanding about the risks and the alternatives to the course of action that we propose. And if we fail to communicate, if we don't bring them to that understanding, then we're breaching our duties. And it's kind of an anti-bullying rule. It requires that we keep them posted and up to date with what we're doing, and maintain that clear line of communication. And if we're pushing them too hard, then we're not doing that. RPC 1.5A, this is the fees. RPC, all fees have to be reasonable, and that means you can't squeeze your client when it comes to fee issues. There's an interesting disciplinary case in Ray Marshall. Mr. Marshall, who is now disbarred, had written a flat fee agreement with his clients. Then he sought additional fees on top of that. He then sued them, filed a lien against them, and then abandoned them at trial after they wouldn't settle the case. Obviously, that's pretty egregious set of facts. But the Supreme Court of Washington said that he attempted to squeeze his clients for additional fees despite a flat fee agreement, and he tried to bully them into a settlement. So they used that language, squeezing the client and bullying them, and they pulled his ticket for it. Hopefully, none of us are even close to that area of practice, but I just encourage you to be very, very careful in these areas and be conscious of your influence over your clients. If the relationship with the client gets to the point where it's really not working anywhere, right off into the sunset. J.D. Smith mentioned this yesterday in slightly different context, but I encourage you to really think about and judge your clients as objectively as you can. And if it's not working, if you feel yourself going over the edge, there are answers. If you do, remember to keep RPC 1.6 in your saddlebag. These are the rules for termination. It's a long list, but go take a look at the rule again if you're in that scenario. And also remember that in your other saddlebag is your duty of client confidentiality. That lasts well beyond your attorney-client relationship. You're going to take that with you as you ride all the way back to the brand. So don't forget your duties there. Okay, switching gears, cultural competency. For those of you that are WSAJ members, if you went to the awards lunch on Friday, I don't think you could sit through that and not recognize that diversity issues and cultural competency affects every facet of our practice. And these are pressing issues in a post 9/11 world. Not that they weren't before, but they're in more stark relief now. And I think it should matter to all of us for a number of reasons, but the most important reason is because it matters to our clients. Our client base, and I don't think this is true for all groups of lawyers, but our client base, the trial lawyers' client base, is as diverse as our population. And my apologies to Oregon attorneys that I'm from Washington, and most of my statistics are Washington-focused. But to prove a larger point, the Washington state population, 27.5% minorities. But Washington State Bar Association membership includes only 12%. So that's a big gap, right? A 50% gap. I think that matters for a number of reasons, but to briefly steal, and I go into more detail in my materials, but to steal an analogy from the medical profession, there's a number of great studies out there that have demonstrated in a statistically significant way that when you have greater diversity in your, in that case, healthcare professional population, you get more access for diverse patients, better patient choice and satisfaction, and better provider communication. These are essential elements of our relationships as well with our clients. I think it's our duty, especially because we represent the individuals out there, we represent these diverse populations. It's, I think, our duty to encourage and foment diversity in our ranks, because it will only serve to improve our service. Someone was asking me before this, well, so you're talking about diversity today, and I said, yeah. It's like, oh, that's funny, they got a white guy to talk about diversity. And I said, yeah, I mean, shouldn't a few more white people talk about diversity issues, right? Why is it that only the people of color have to be the ones to remind us, you know what, this is an important issue? So I'm excited and honored to be able to talk about it, but I do think it's an important issue. So that's the kind of first half, right? Let's do what we can to encourage and promote diversity in our own ranks. But then when we sort of scale back to our own individual practice, what can we do? Well, again, I'm trying to make sure we get our ethics credit, so I'm going to pull it back to an RPC. There's a great RPC on point. Discriminatory acts that are discriminatory or prejudicial to the administration of justice on, any one of these categories are, not surprisingly, explicitly prohibited. So to pull it back into bullying, I think this is a good one to have in your pocket if you even if you even catch a hint of any sort of race or other protected class-based bullying actions. So keep that in mind. Excuse me. How am I doing on time? 20 minutes in? Okay, thanks. So here are our clients, and even members of you here that are members of diverse groups. I think it's worthwhile recognizing that all of us can work on these issues, right? Because you can't look at this and not see at least 10 faces that are very, very different than yours, 10 cultures that you don't belong to, and that you may not have much exposure to or understanding of. So this does impact all of us, and we have these duties to communicate with our clients, but these issues, cultural difference issues, can create huge barriers for communication. And why does that matter in the context of bullying? Well, failure to communicate can often lead to misunderstandings and then a perception, if not a reality, of bullying and aggressive behavior. And it can go both ways, but it ultimately results in poor client satisfaction and poor client service, which again is ultimately what we're all here for. I think attorneys can end up bullying in these situations without even realizing what they're doing. So this is the sign for cultural competency, and it's an interesting thing in its own right. I'm not quite sure I follow what it means, but I think it means we're each reaching into someone else's culture and trying to learn what we can. So how do we do it? I think the first step is the hardest step, and it's not reaching out, it's looking back in and confronting your own individual biases about the person that you're dealing with, about their culture. Do you have certain assumptions that you make just when you see that human being or someone else from that culture? What are those biases, and why do you feel them? And or do you alternatively consider yourself to be colorblind? I don't see these issues. I don't see color. I just see the person behind the eyes. I think that you're fooling yourself if you believe this about yourself. I think this is something that we tell ourselves to make ourselves feel better, because the more challenging thing is to deeply engage in your own mind, in your own soul, and really understand where you're coming from. Because you might not like what you see, because we are all different, and we have some of these things are hardwired into us. We have this affinity for the like, right? We know and understand what what is like us, and we don't know and may be afraid of what is not like us. So I think it's important to recognize that seeing color is okay, and we need to do that to kind of get past some of these initial biases, because I think that we just have to make the effort. So what do you see when you see these, when you see folks from a different culture, a different race, a different religion, dressed a different way? You got to get through these initial barriers. And once you do, then you can dive in to another individual's culture. And someone at the Lavera seminar mentioned this too, and it was in a slightly different context, but it was about getting to know your client. And boy, if you need to get to know all of your clients, and you do, when there are cultural issues, it's magnified, by a factor of 10, right? So get off your tuchus, get out from behind your desk, get out there, meet with your clients in their communities. If you're lucky enough to be invited, go where they break bread and where they worship, and you will learn about the culture. And that's how you break down these barriers, is spending time with people from different cultures and honestly opening yourself up and working to understand them. And it can be, it's almost a little bit easier to do that when you're with somebody from an entirely foreign culture. It's a little bit harder, to do that when it's just someone from a different neighborhood, a different, when it's a little more subtle. And I can't pretend I have the answers on that. I just encourage you to seek those answers in your own right, because getting there is critical to our profession. Also remember that you have a duty to arm your clients that are from usually different countries, to educate them about American culture so that they have the strength to withstand bullying, attacks, et cetera, and they have an understanding of the judicial system in which they're going to be judged ultimately, right? So this culture sharing does go both ways. Okay. Bullying threats. So this is often where the rubber meets the road in bullying threats, and so this piece, I encourage you to kind of be looking at it from a duality, right? Are you doing these things, and are they being done to you and your clients, and what can we do about them? There's a very fine line in litigation between what's acceptable and what's sanctionable in terms of making specific threats. The analysis turns, and on this is the extortion statute. And I love this cartoon, by the way. I think it's Calvin and Hobbes. I'm not sure though. But the analysis turns on whether the threat that you're making is extortion, right? So you're guilty of extortion by means of a wrongful threat if you make a threat about, and then there's this list in another RCW, 9A04-110, and there's this long list, right? Accuse someone of being of a crime wrongfully, expose them to hatred, contempt, or ridicule, reveal information that they're seeking to keep concealed, and then to testify or withhold testimony, and then the J is kind of a catch-all, anything that you intend to substantially harm them, right? So these are the risks, the potential elements of a wrongful threat in the context of extortion. But there is the obvious defense, going back to the original statute. And this is where it gets a little bit confusing, so just bear with me right here. So it's a defense if the purpose of the threat was to induce the person to take reasonable action to make good the wrong which was the subject of the threat. So what the heck does that mean? There's a case on it, very interesting case, State versus Pauling. And in State versus Pauling, the analysis turns on this lack of nexus requirement. That's how they articulated what we just saw. And the quote is that the threats that bear no relation to a plausible claim of right are prohibited. It's extortion if you're doing that. I think that the best example in our practice is a disciplinary case. It's a very, very short, it's like a one-paragraph little report of in regress. And the only way that I felt like I could think it through was to come up with just two scenarios. So the first scenario, and this is again a sort of a version of this lack of nexus in the threat. And this happened to me in litigation. So I know what happens, and I think we need to be aware of it. So this is scenario one, and I think this is not extortion, this one. So Jim steals Mark's WSAJ desk book, all right? Mark says, I'm going to report you to the cops unless you give me my desk book back, right? So that's a threat, but there's a nexus with the plausible claim of right? The plausible claim of right is, that's my book. I get it back. If I take you to the cops, it's a way for me to get it back, right? That's a nexus. That's okay. Scenario two, and this is one maybe we're much more familiar with. Jim runs over and injures Mark with his car. Mark sues Jim. Jim, during the course of the litigation, finds out that Mark's got a little someone on the side and having an affair. And he says, well, unless you settle your case, this auto accident case, I'm going to tell your wife that you're having an affair, right? So is it related to the plausible claim of right? Well, yeah, he is saying, I want you to dismiss this case, but there's no nexus between the elements of the threat. If he follows through with the threat, that's how I like to think of it. If you follow through with the threat, does it get you there? Does it get you to what your claim of right is? And so if he follows through with the threat here, well, Mark probably gets divorced, but it doesn't change what happens in the litigation, right? There's still this claim of right of Mark suing Jim. So be wary about these kinds of threats, because I think that they're a really insidious form of bullying. It happened, to me. I won't go into details, but the in regress thing was similar. A guy found out that somebody had been cheating on his taxes. The defense attorney found out that a workers' comp claimant had been cheating on his taxes and said, I'm going to take you to the IRS unless you settle the case. And he ended up getting sanctioned by the Bar Association for it. So it's a good case to know. Now, this is a very important subcategory of these types of threats, and this is in the immigration context. And some of you, I know, are very familiar with this. New suggested RPC 4.4, it's a suggested comment to RPC 4.4, and the comment is effectively making threats related to immigration prohibited, right? And this is the same sort of deal, right? You have a client who is undocumented worker who suffers some injury. You're trying to pursue this claim on their behalf, and then all of a sudden there's the issue of, well, are you an undocumented worker? And ultimately the threat comes that, I'm going to take you to the INS. I'm just going to report you. I'm just going to do my duty and report you to the INS if I find this out, right? But what they're really saying is, this is going to happen to you unless you drop the case. All right, those are the kind of threats that happen, and those of you that represent these populations, I'm sure, have seen it time and again. And there's been some great work by a number of folks who have worked very hard to add this comment, because I'm very certain that RPC 4.4 plus a whole lot of the other RPCs that we've talked about prohibit this kind of activity already, but the new comment to the rule, which has been effectively approved by the Board of Governors in Washington and the Washington Supreme Court. It's just up for public comment now, which is the last step. But this new comment will explicitly prohibit this type of nonsense. So know about it, and I think if it happens between now and April of next year, when the public comment period ends, if it happens to you, still go after them with this rule and all the other RPCs I've mentioned, because this kind of stuff is absolutely prohibited. Also, be wary of the veiled immigration threat. So it's not the explicit, I'm going to take you to the INS. It's, well, let's just do a whole bunch of discovery about, your documentation here, and let's talk about your family and who else in your family here is working and so forth. It can be much more subtle and equally insidious, and I think it's still objectionable. And I encourage you, if that type of stuff is going on, to don't shrink away from it. Don't be afraid of it. Address it head on. Address it in person. Address it in a letter. And if you need to, get a protective order against this kind of stuff, because there's a clear but fine line between reasonably calculated to lead to the discovery of admissible evidence and reasonably calculated to threaten the heck out of your client. And when they're asking those kinds of questions, when it has nothing to do with the case, they're trying to threaten your client and put a stop to it, because that's grade A bullying. Okay, a few last tips. How am I doing on time, guys? All right, sure, okay. Okay, so a few of my tips. 5 ways to be prepared. I couldn't believe I found this image. Yeah. So I actually have more than 5 ways, but I just wanted to put this up here. But even Charlie here likes to prepare, right? So responding to bullying, I think, is anticipating it ahead of time, being prepared, and being able to respond. And it's not just you, it's your client. Prepare your client to deal with this stuff, especially, the rubber meets the road in deposition, right? And so get your client ready to deal with this kind of nonsense. Practice it with them, and try and get under their skin and see if you can get a rise out of them, and then work them backwards from there. I think develop a handful of sort of courteous responses to the sort of more vitriolic outbursts that you can expect. I do, at depositions, I encourage you to bring a list of RPCs so that you can cite them if need be, because one thing you're going to be doing is making a record to deal with this stuff down the road. It seems, maybe a little bit unrealistic, but I think if you maintain the right tone and demeanor, it can certainly help. And you gotta maintain your composure throughout the entire thing, and that's it's hard to do, right? Emotionally charged, you care about your client, they're throwing personal insults at you, at your client. What we want to do, naturally is respond in kind and fight back. And don't get me wrong, I encourage you to fight back. It is absolutely our duty to fight back. But don't do it out of emotion, and don't do it responsively. Do it strategically, with purpose. Think it through ahead of time, and your fighting back doesn't have to be, a better barb. It doesn't have to be a better insult, because actually that's just undercutting your position. The right type of fighting back is to maintain your calm, your cool, your composure. Lay down a very crystal clear record, and use that as ammunition for later on. But you do have to fight back, right? Because bullies, they feed off of weakness, they feed off of fear, so it's going to get worse and worse. I don't want anything, that I said to imply today that we don't want you to fight back about this stuff. And in fact, it's quite the opposite. I want to hopefully arm you with something to use. Don't blink, and always keep your poker face throughout the course of the proceeding if you're dealing with this stuff. They have a motive. They're not just a-holes, although many of them are, but they have a motive. They want to divert you and distract you from the important parts of your case, right? That's what they're trying to do. They're trying to knock you off your game. Don't let them do it. Keep your cool. Don't lose sight of what's really important in the case, which is your client and your client's rights. Just a quick one. I mean, this is maybe a personal preference thing, but don't do the I'm going to call the judge idle threat stuff. I don't think that gets you anywhere. Really, overall, I'd say leave the judge out of it if you can. I think we probably all experience this, and if you talk to judges about it, the last thing in the world they want to do is deal with this sort of petty bickering, because that's how it'll really be seen. Unless you make a really crystal clear record and you've done everything else, all the other things that we talked about, and you'll hear from the panel and Lori later, last case scenario, I think you go to the judge when you absolutely need to. Instead, prepare, work twice as hard, and I was going to steal Mike Wampold's line, but he just got up and left, so I'm not sure I should give him credit for it. But I do like his line, which is, you got to skate the clean program and fight the good, clean fight. And I think that if you do that, if you're conscious about it at the front end, then at the tail end, when you have your day, when your client has your day, when you're at trial, you'll have a polite, professional version of this.
That's like a snowball sandwich. Maybe like another one.
Listen, jerk, when I tell you to come, you better come. What, are you gonna cry now? Come on, cry, baby, cry for me. Come on, cry.
Deep in the recesses of my brain, a tiny red-hot little flame began to grow. Something had happened. A fuse blew, and I had gone out of my skull.
Hey, good! I'm coming like
All right, I think you get the idea. Anyway, that's all. Thank you guys very much. Appreciate it.
That was awesome. Thanks, Sam. That was great. So the way we're going to kind of do this program is we've kind of allocated about, 20-ish, 30 minutes for some question and answers, and we will be coming around and collecting your questionnaires, and that's going to kind of help prompt our discussion. And on our panel today, we also have Lori Haskell, who we'll be hearing from in a little bit. But we also have Lincoln Beauregard, who's here today. And as you guys all know, he was one of the founding members at the Conley Law Office. And what I didn't know is before attending law school, he was enlisted in the Air Force. We also have Chach Duarte White, who happens to be a good friend of mine. She most recently was the diversity program manager for the WSBA. She's also served as an adjunct professor of legal writing. She's also worked for Northwest Justice Clear Line, and so she will be giving us some insight as well for our question and answers. And of course, Sims is here as well, so we've got a panel of 4, and Will be helping me kind of moderate some of the discussions and passing around the microphone. But we really encourage you to help us kind of discuss and flesh out this issue. So I'll be collecting some questionnaires, and we're going to turn the time over to Sims to kind of get this discussion going, and Chach as well down the line.
One thing I want to say, Lori did a handout of her materials here, and I really encourage you to take a moment and read those, not at this particular moment, but after we're done here. It's great information, and I think from an important, unique, and authoritative voice. So take a look at those. I thought maybe we could just go down the line and get your sort of initial take on some of these. Is that all right? Ready to go? We want to maybe Lincoln? Do you want to start? And what's that? Just general subject. Yeah. Sort of on the general thing. We'll go down the line, then go for questions from there.
Well, I guess some of my initial thoughts when we talk about the topic of litigation bullying is that I think in every circumstance is it just matters about context for any given interaction. And I think the importance of the context includes who are the personalities involved, and obviously what are people's motivations. I've probably in my history of practice I've never been accused of being a wilting daisy or whatever the phrase is by anybody, but, you know, I've been practicing about 10 years. As most of you know, with each day that you practice, you start to realize, you know, the more you are fighting about things and being unpleasant, the more work you're creating for yourselves. And in a practice where we're all trying to, you know, earn a living, you start to kind of tire of that, and I know that's been my experience. One of the things that I've kind of started to try to do more in my practice when dealing with a contentious situation in a deposition or you know, an email exchange or a phone call is, rather than, you know, always meeting bullying with bullying, which on occasion I certainly do. I mean, there's circumstances where I figure out the personalities and I think I've got to meet this person square on, and there's those circumstances. But more often than not, I've found in my practice, I'll have a situation. I'll even tell you a quick story that I think is kind of funny, kind of a different way of dealing with bullying, in that I have a case with one gentleman who's very aggressive, who will remain nameless. His name's Andrew Cooley, and I consider him to be a good attorney and a good track record, and his matter of practice has often been to be very aggressive. And knowing my own personality to be, you know, sometimes very aggressive, I thought, I don't want to have an aggressathon for the next couple of months with this guy. So in lieu of, you know, when he sends me the email saying, you know, whatever, wanting to fight over who needs the continuance when he needs the continuance, I'll send him an email, and I'll paraphrase, I was rereading my email this morning to him, I said, and there's some history behind this, but instead of saying, Andy, I start off my emails and I say, Your Majesty, and then the next line is, you know, obviously we can reach some concession. I'll concede to you, sir, you know, because the king's not going to negotiate with any man or any commoner, is what I told him, and gave him what he wanted. Point being, I just decided, you know, why not just kind of play to his, you know, power position thing and just say, you know, I'll give you whatever you want. I find sometimes that that's effective, and more specifically, you know, I'm imagining a context where, you know, if you feel as though somebody does have the stronger, more aggressive personality by nature, I think sometimes just giving them what they want and make them feel foolish by virtue of their level of aggressiveness is sometimes the best way to deal with a situation. So that's my stream of consciousness thought process as far as just reaction to what we've seen and trying to incorporate some of my own thoughts and experiences.
Well, Lincoln, it sounds like you have, from time to time, succumbed to sarcasm. And I have never, ever been accused of succumbing to sarcasm, so I guess I can just learn from you. Well, Sam, so one of the things I was going through my head when you were talking, I mean, I know that there's all these RPCs, et cetera, but perhaps I'm the only one in this room who, I don't know if I've ever gotten anywhere in a case by saying, well, I'm just going to report you for breaking the RPCs, and this RPC says that you shouldn't be doing this, Mr. Defense Attorney. You're supposed to be being nice and professional to me. And I don't know. I mean, do you brief that? Do you quote that in a deposition? And the flip side of that also is, I don't see that the courts are real helpful to us. Because it's always, you know, just go away, quit fighting, go resolve your differences, and come back when you've done that. So it would be, to me, it would be different if we had a forum or a tribunal or whatever for the RPCs, and I don't see where we do. Yeah.
Well, I certainly wouldn't do it in that tone of voice. But, and I agree with you. You know, there's practical limits, but I think first of all, a lot of what I was talking about are the exception rather than the rule, right? And you know, if we you can come in and diffuse a lot of these situations, and if we don't immediately respond in kind, if we take a break, then we can kind of get past the nonsense and get to the nut of the matter without having to bother with any of this stuff. And I agree with you, there's not a lot of great precedent out there where courts have relied on the RPCs in sanctioning counsel. And is that because it doesn't happen, or is it because we don't bring well-briefed motions on the issue and make it happen, right?
Well, let me ask this question. If you're in a deposition and things are getting out of hand, as they can in depositions, do you say to defense counsel, what you're doing violates this RPC or that RPC? I mean, is that something that you employ during a deposition?
I have. Yeah. And I usually don't, I would probably start off by a nice reminder, and I shouldn't say start off, because it would probably take me a long time to get to that point, right? So I would start off by trying to just keep things cool, and one of the important ones is to, part of the making the record is not saying you're violating this RPC, it's putting things on the record that aren't already clear, right? Raised voice, wild gesticulations, that type of stuff. When I'm talking about when we're beyond the pale here, right? When this stuff is really happening. It's not every dep, it's not every 10th dep, but it happens. And when it does get to that point, yeah, I would be happy to remind opposing counsel that I think that they're, they've gone beyond that point. We either need to take a break because you're being unprofessional. I think you're violating some of the rules. And if there's one great one on point, and frankly, it was very helpful, for me to go think through all this stuff in preparation to come here. And I don't always have this at the tip of my tongue. And so I have used it in the past, and I would in the future if it got to that point.
I think that's just an interesting point that Sims and Loy are raising is I think oftentimes we forget that these rules exist. And how many people think, you get to a point where you're dealing with opposing counsel and then sometimes that barrier is crossed. And maybe it's, the better question is, should we think about the RPCs as we engage in the practice of litigation? As you become more experienced, you start to sort of develop your own pattern for how you deal with things. But as a younger attorney, I think you oftentimes are like, do I go to the judge, or do I go to my colleagues, or what do I do in this situation? I learned in law school, and I took the bar exam, there's all these rules that govern all this conduct, and then you see it every day. What do you do? When have you crossed the line? I'd like to take some questions about what people think about, the rules that we have and when it's appropriate to raise them. Does anyone have any thoughts?
Immigrants, if you will, over whether or not they had insurance, whether or not they had a license to drive, and they take it from there. And I've heard that it's pretty rough before, but it sounds to me like if you don't have supposedly too many tools in sitting in on one of those statements under oath, but maybe talking about the RPCs would cross that line from dropping it down.
One of the panelists respond to that question.
Well, I think, particularly working at the bar, the RPCs are there for a reason. And I do think at times you have to go back and say, we're all bound by this. And this is our professional conduct that we said how we would act. And I do think, while it's not like you're gonna go tattle to the parents, but I think we can all agree that we agreed to be bound by these rules. And I think you need to use them when it's appropriate.
I personally don't think ever in my practice, and I'm not trying to go counter to personally, I would never cite the RPC to somebody, and that's just my practice. I wouldn't ever do it, because I think that every lawyer's got their rule book, and so that wouldn't be my style, and for some people it might be their style. I think one thing that people are sometimes forget, and I try to remember myself too more, is when you're dealing with a bully on the other side of the litigation, you know, everybody wakes up in the morning, they put their pants on, they go to work, and they've got their hobbies and their interests and their motivations and the things they like and they dislike about their job. Sometimes one of, I think, the best ways just to deal with or even cut off the potential aggressiveness in litigation is get to know your opposing counsel, you know. Sit back with them for 5 minutes before a deposition, have a conversation with them and realize that the insurance company's given them 12 different files and talk to them about or 100 different files, talk to them about that and have them recognize and you recognize that they're just a real person who's got their own stresses and everything else. I think that's one of the sometimes more effective than necessarily citing the RPCs to somebody. And I might even be so bold as to say, you know, I'm gonna challenge myself. Next time I'm ready to tell somebody where to go in the middle of a deposition, maybe I'll go out, let's take a break, walk up to them and say, hey man, you got a stressful job. You know, if I know you don't mean to be an a-hole, but you're coming across that way and it would never be, that's not who you are, so let's go. I think sometimes that'd be personally, I'd be more likely to do than I would be to sort of cite some of the RPCs.
Actually, a comment, you know, my experience with depositions is I've had the same experience you've talked about. Sometimes by developing a personal relationship with the other lawyer, you can tone things down quite a bit. But also, I've also used the intervention of the court more than once, and I've used it where you can actually call and the judge will make a ruling over the phone. I've actually stopped a deposition and actually went in, brought the transcript in, and had the judge rule that these things are inappropriate or this is appropriate. And in an extreme case, one time I actually had a judge preside over the deposition because the deposition was so contentious. So these are all tools that you can use, and I think getting the intervention of the court is something that you can do to stop your client from being bullied or ridiculed or whatever.
I just want to respond to that. I didn't mean to imply that you shouldn't. I just don't think it should be your first step, and it's more the idle threat to do that and then not following up that I find ineffective. But if you get to that point, you know, and you need to do it, and you made a good record, you know, it is a great tool.
I'm interested with regard to the extortion example that you used. It seems we often have clients who claim more earnings than they paid taxes on in the past. And so is it appropriate in a trial setting or a deposition setting to inquire, did you pay taxes on that money you're claimed to have lost? The implication obviously being that your client's a tax cheat, which probably really shouldn't have anything to do with his claim, but I'm sure almost certainly will.
Well, so that's it. It's a great question, and the problem with the tax thing, as opposed to say the immigration thing, is that it is probative, right? You've in a lot of cases, at least you know, for me, you presented their tax returns as part of your damages claim, or at the very least, you've made a damages claim, and it is probative to look at what they stated their earnings were on the taxes. So it's right on point, and they're entitled to the discovery, and I don't think it's bullying for them to push the issue really far. The step in that case, so unlike the immigration thing where even I think some of the pointed discovery may be in violation of the rule, on the tax issue, it's a little more tricky, and it's really the explicit threat like in regress, where it's, I'm going to give this to the IRS unless you settle the case. And if you can if that's pinned down, then that's violation.
Throw in then that he's an illegal immigrant that
right, yeah.
has not paid taxes.
Yeah, well, I mean, if I would think that any of the immigration-related issues are not probative unless it is some way involved in the case. You know, that I think that you'd be able to put a stop to it with 4.4.
Isn't that a different standard then? You can do it with a citizen, but you can't do it with an illegal immigrant?
No, I don't think it's a different, because it's a different issue, right? One of them is probative and one of them is not. The tax issues, going into that and learning more about damages is probative for the defense because they get to defend against your damage claim. That's fair. But the fact that someone is or is not documented in terms of their immigration status has nothing to do with whether they got greased in a crosswalk and can't work. So.
Sorry. I'm referring to the CLEs case and when the plaintiff is claiming wage loss and they're not a documented citizen. I think it does have probative value because of the different values of money in Mexico versus U.S. But one other comment I guess I wanted to make was, I have never really had a problem. I think I'm kind of in Lincoln's camp in not so much going to the rules of professional conduct, in citing them and calling them out on those, certainly keeping in reservation that these things are being violated, these rules are violated, but keeping a paper trail, documenting what's been going on. And over time, if it does become an extreme situation, I have gone and sought court intervention and cited the rules. The rules provide for this, I think, under CR 26, Local Rule 37, sorry, Oregon, and Rule 11. And I've not had trouble with getting sanctions for this kind of behavior. And I'll go ahead and cite the rules of professional conduct that have been violated if it's warranted. I don't want to look petty to the court, but it'll come up, and I've obtained sanctions that way.
We just don't get ethics credit for talking about the CR, so. I'm just kidding, that's great, it's more to it.
Videotape, people. Videotape your depositions.
Yeah.
That's one of the most effective ways to deal with very, very difficult opposing counsel. Turn that camera on and watch their behavior change.
Yeah, I agree with what Liz and Lori just said. I think making a record is very important, whether you have a video camera there or whether you're on the record in a deposition. If opposing counsel is doing something inappropriate that you think crosses the line, stand up for your client, stand up for yourself, and make sure that you make a record of whatever is going on. For example, I had a case one time where I had a client that I was representing in an employment discrimination case, and she was being sexually harassed by a guy who had been previously convicted of second-degree murder. So this was a really tough guy, and she was horrified of having to go into her deposition and wondering if opposing counsel was going to bring the guy who had been sexually harassing her. And I said, well, he's entitled to do that, but if he's being inappropriate, don't worry, I'm going to protect you and make sure that nothing happens. Well, this guy was just roaming around in front of the deposition, and I talked with opposing counsel. I said, my client is afraid of your client, and I really want you to know that if this gets out of hand, we're going to make a record and do what we can. But it was just that, the guy was drawing, I think he was drawing pictures, and he drew like a hangman's noose. I mean, it was really egregious, really egregious. He had drawn like a hangman's noose or something, and it was just totally offensive. We made a record of it, but that's the kind of thing that can happen, and that's where you see it, sometimes bullying can be effective, but you got to really step back and think about, is this the way that you want to practice? And if you're on the other side and your client is being bullied, what are you going to do to stick up for your client? And it's not one of those situations where you're likely going to sit up and cite some RPC, but you need to do something, I think, to take care of your client and decide how you want to practice. And with Lincoln and Liz, I do think at a certain point in your career, you get to know people and they get to know you and they understand how you practice, and you probably deal with a lot less of this stuff than when you're a younger attorney.
Actually just got done with a month-long trial in this really horrid case, and I was trying to look back and learn what I could from it, learn from the experience. And it was one of those cases where I had co-counsel, and defense attorney was very difficult, and we did get caught up in just pounding the crap out of each other with motions. Sorry, with just really back and forth with motions. It was exhausting. And so when the trial was done, I asked for advice from a couple different mentors, and I ended up calling the defense attorney and saying, hey, we're going to be across the table from each other again, and let's, I don't want that to happen again. So what do we need to do to be able to work effectively together? We talked for, 20, 30 minutes on the phone, and then we had another issue come up in this case, and before you knew it, I got hit with a motion for when I was supposed to be here after I filed a notice of unavailability. So I called him up and I was like, what are you doing, man? We just got done talking, And so I just don't, when you're already in the middle of a case where everybody is now not getting along, do you have any advice for how to get disengaged with that and get it back on a playing field where it's about the clients and the cases and not about the attorneys and who's winning?
Concentrate on your client. Your client is the most important person in this entire scenario. And if you put your focus on your client and what is best for your client, it is certainly helpful in maintaining the focus there and not getting, and as Sims was saying, it's a tactic to throw you off your game. Yeah. And that's exactly why they do it. So, and if you know it's a tactic and you know that's what council's trying to do, I mean, that helps you think it through and do your utmost. And, you know, it happens to all of us. It happens to the best of us, believe me. But if you put your client first and foremost, I find that's helpful for me in those situations.
I agree with Lori. I just want to say, if I'm in one of those situations where I'm writing that email and I'm getting ready to send it, and maybe it's going to raise the temperature, I'll look at it, and not to say I always abide by it, but I ask myself, is this going to advance the interests of my client? And you know, if there's some psychobabble in there that I think is going to advance the interests of my client, that's one thing, and maybe I'll send it. But at the end of the day, I find that to be the most calming thing, is just making a decision, am I doing the right thing for the interest of the case? And that's all, I mean, I think that's all you can really do.
I had another question here.
Actually, I just want to respond to Roxanne. For me, the best way to disengage is to stop talking and start writing. Instead of going on the phone and trying to work it out that way with that opposing counsel, I write letters, and in my mind, even though I'm addressing it to opposing counsel, I'm actually talking to the judge, because this letter is going to become an exhibit someday, and so I want it to be very polite, and I might cite some law in it even. And if I'm really upset when I'm writing the letter, I might hold back and not send it for a day and just make sure I'm not saying anything outrageous. Because I do want the tone to be cool and professional. I don't want it to look like I'm just ranting. But if I do that, then it sort of puts a level of separation between me and the nasty opposing counsel, and I think I can get through it then.
Thank you, and we have another question down here.
Okay, you can start.
Thanks. This is one of those rare occasions where I agree with Lincoln, and I thought I'd stand up and acknowledge that. I'm kidding, Lincoln. As Lincoln said and as Liz said, I don't cite RPCs to people, but for a different reason. 25 or 30 years ago, I was Andy Cooley's first supervisor. And I tried, I promise you, I tried. I swear to God I did.
Is that where he learned all this stuff?
He didn't learn it from me, Laurie, you know better, because you worked with me too. And they don't change. And so it's kind of pointless to cite RPCs to him. I'll give you another example. Bradley Marshall, who you put up because he was disbarred, is an inveterate bully. After he was disbarred, he sued the Bar Association and the Supreme Court. I know because I had to defend the Supreme Court. So it's just their style. They do it all the time, unless it's somebody who inadvertently does something stupid and you can call their attention to it. And I found the most effective thing, here's the dumb thing I do. I get my email open and I take out the address in the email, so I can't inadvertently send it to somebody. And then I type the email I'm thinking of, and I just put it in drafts, and since it doesn't have an address on it, it's never going to go anywhere. But then I find some effective way to use it that I think maybe really delivers the message in a way that will work. And I mentioned in my written comments, I had a trial a few years back. And by the time of trial, the defendant had finally gotten around to getting a new attorney who didn't suffer from the same disease. But the case began out of bullying. I represented some East Indian Muslim Canadian real estate developers against a municipality, so I had some kind of tough clients because they wanted to build condos that blocked the view of Puget Sound. But the case was characterized from the beginning by bullying by the municipality. And then the attorneys continued it. They bullied 2 previous attorneys out of the case. I think they had 3 appeals in the case before I took it over. And so the theme of my trial became bullying. And during voir dire, I developed bullying. I had a school teacher on the panel, so we talked about how do you deal with bullies. And we didn't mention the subject again until the end of the case. And by this time, they'd heard all the behavior of the municipality, and they'd also heard all the behavior of the attorneys, because I'd amended the complaint to add a claim against the attorneys. And so at the end of the case, we talked about bullying, and I said, okay, now it's, we're in the principal's office, here's the bully, deal with it, and we got a $13 million verdict. And I think since the attorneys had to pay part of the judgment, that maybe that's a way to deliver the message. But I don't think they change. I mean, I think you just have to keep your head, you have to be cool, as Lori said, focus on your client and what's best for your client. Never respond in kind, unless you do this kind of email to yourself thing. And find an effective way that delivers the message to them and does it in a manner that's satisfying to you. Well, this was the dispute was over a building permit, okay, and so they delayed it for like 13 years. And 8 years of that delay was caused by the attorneys when they neglected to mention that the previous settlement of the case was invalidly done because it wasn't an Open Public Meetings Act. And so they had a whole series of things where they led my predecessors to believe it had been settled when in fact they knew it hadn't. And a month before my first trial date, they came into court and said, oh, by the way, it's an invalid settlement. So we just amended the complaint and added them as individual defendants and had a civil rights claim for substantive and procedural due process.
Can I briefly respond to that? Because
yeah.
That's a great. My first trial started 2 weeks after I got my license, and it was a 3-week legal mal against Bradley Marshall. And we won, and he had bullied the heck out of 16 longshoremen that had suffered racial bias and discrimination, and then suffered the slings and arrows of his work. So the amending the cause of action to add attorneys is interesting, and if you can make it work, that's fantastic. So I don't know. I just want to add that coda that and the RPCs. The reason why I focused on the RPCs, apart from the ethics credits thing, is that we think about the CR stuff, we think about the sanction stuff, but I don't think we think about the RPCs. So it's just, I want everybody to think about it and have another potential set of arrows in your quiver. Are we switching out right now, or we need another minute or two? Okay. So because Lori's going to go soon.
Yeah, so we are going to go ahead and hear from Lori Haskell now, and then after she speaks, we'll have another question and answer session, so definitely keep those questions coming and comments, it's good. Lori Haskell, prior to going to law school, she worked in television for over 10 years. After law school, she clerked for the Chief Justice in Alaska. Getting to know Lori a little bit better, she really is a true warrior, and she has a heart of gold, and she's got lots of experience, and she definitely has a diverse perspective, and she's got a lot to share with us today about litigation and bullies.
Thank you. I find that a lot of bullying takes place in depositions, and it is good to always create a record and keep things on the record. And I'll just share with you an experience I had very recently in a case. I was taking the deposition of the owner of a company. It was an employment matter, and the defense attorney at one point, just kind of lost it and said, I want the record to reflect that counsel is pointing her finger at the witness. And I said, and I would like the record to reflect that it is my index finger. And the other thing that you can do in depositions, if you have a really, really, really tough opposing counsel, is, you don't have to hire a videographer to bring a video camera in and record opposing counsel's behavior. You just go bring your little camera in, set it up on a tripod, and hit the little go button there, and make your own record. And, they'll yell and scream and say you can't do that, and you say, well, yeah, I can, and not only can I, but that is what I am doing right now. So, rather than put a lot of money into it, but if you're having a really difficult time with opposing counsel, that's one thing to do. See, I have a completely different problem that I don't think anyone else on the panel has, and that is my height. And I walk into a room and people, you know, I think people attach being competent with how tall you are sometimes. And so I walk in a room and it's like, oh, wow, okay, this is going to be easy pickings. And so, you know, things get off on that foot sometimes for me. And I've had, I don't have tall women do this to me, but I have men a lot of times try to physically intimidate me, and I'm not even sure they're aware of it. But it's something I'm very aware of. So, I mean, all you can do is hold your ground and wear high heels, and I'm sure that Lincoln doesn't often do that, but I do. And I just find that depositions is where this behavior is going to happen the most. So I have some suggestions in my materials with regard to have a game plan when you go into a deposition. And you know, there are various things you can just sort of have in your hip pocket about how you're going to act or not act or react or not react, as the case may be. And I think and I talk about it in my materials a little bit, I mean, we prepare for cross-examination, we prepare for trial, and we prepare for depositions. But one of the things that sometimes we don't prepare for is, you know, how we are going to act or react when faced with a situation in a deposition where, you know, there's literally no one there with us sort of overseeing things. And I find, and does anybody else, I mean, maybe I'm the only person this ever happens to, but as a sole practitioner, I find the big firms want to come in and really throw their weight around, particularly at the beginning of a case. Does anybody else have that problem, or is it just me? Okay, you're making me feel better. And the way I deal with that, and I just had some depositions with a firm that I won't mention other than to say that it's named Davis Wright. But anyway, where the opposing counsel came in and with a bunch of exhibits, I mean, a big stack of exhibits for a deposition, and literally walked in and threw them across the table. I mean, they hit me. And what I do in situations, particularly at the beginning of a case, is see if I can let all the dust settle and by simply not reacting. And if I don't react and I don't react and I don't react and I don't react and the behavior continues, then I'm going to start drawing my line in the sand. But anyway, that's something to think about what you want to do in terms of how you're going to draw your line in the sand. And I also think and we talk about it a lot as trial attorneys, about being authentic. So you have to act or react in what is authentic for you. Are you going to try to diffuse the situation? Are you going to, try to inject some humor into it? Are you just going to, come back at the other attorney? Just think about it in advance and be authentic. So I know that we're supposed to be talking about bullying, but I wanted to take a bit of a different tactic. Is this the... because I was talking to someone the other evening who told me that they didn't know who Matthew Shepard was. Does anybody here know who Matthew Shepard was? Pardon? Yeah. Okay, good. That makes me feel better. Because the Matthew Shepard in my community is the Emmett Till. And the Matthew Shepard case became very, very important and very, very galvanizing. And for anyone who doesn't know, Matthew was a young man in Wyoming who 3 guys decided that he had come on to them in a bar, so they took him out into the middle of nowhere and stripped him and beat him within an inch of his life, and then tied him in a crucifix position to a fence, and where he was left for 18 hours before he was found. And at that point, he was almost dead. He did live long enough to get to the hospital so that his parents could at least come in and say goodbye. But it kind of galvanized the nation. And so what I'm going to do here today, which is something that perhaps you didn't ask for, but I wanted to do a little bit of cultural competency around this issue because I don't think it gets talked about a lot. Although our organization just went through a rather large discussion around the subject of LGBT issues. So Matthew's mother, Judy Shepard, has devoted her life to going around the country and talking about diversity. Now what happens when I... There we go. And I don't know if how many of you are familiar with Fred Phelps and the Westboro Baptist Church campaign, but if you can imagine, if you would for a moment, Judy Shepard having this happen to her son, and then this is what happened at his funeral. And Fred Phelps is an attorney. He's been disbarred. Well, he's still an attorney. He's just not licensed. And he has this weirdo church in Kansas. And Phelps and his followers have been to Seattle several times, and I have had to deal with him. And I've had any number of friends. My community has to deal with him a lot. So Matthew Shepard's torture and murder prompted the passage of the Matthew Shepard Act, which includes sexual orientation in the federal hate crimes. And that just was passed into law in 2009. And just the year before that, in 2008, here in Washington, we added sexual orientation to our own civil discrimination suit. Now, I'm including this because does anyone here know why Gay Pride Month is in June? Judith does. Yeah. Does anybody know? Okay. Then that's something that you ought to know, because there's a reason Gay Pride Month is in June, and it's because of the Stonewall riots. The Stonewall riots happened in New York City in June of 1969. And those were the days when the police would simply come into anything that looked like a gay bar and round everybody up and take them down and throw them in jail. And one night, my community had just had it, and riots erupted. The riots lasted for 3 days. These people really took over a section of New York. And the cops really couldn't get in or out. And in fact, some of the police had to come into the tavern that they were raiding and be protected because of the rage finally spilled over. So that was in June of 1969. And people, that is why Gay Pride Month is in June every year throughout the country. It is in celebration of the Stonewall riots. This is Harvey Milk, and I would like you all to know who Harvey Milk is, because a lot of people don't, and I just had a judge deny me the opportunity to put Harvey Milk's picture and case in front of a jury where it would have been totally appropriate, because Harvey Milk's murder was where we first heard of the Twinkie defense. That's eating too much junk food, which apparently then makes you go murder people. But anyway, Harvey Milk was the first out politician in the United States. And he's very, very important in my community, and we refer to him as our Martin Luther King. And he was our Martin Luther King because he was the first out politician who stood up in my community and said, you don't need to be ashamed anymore. Please believe in yourselves. Don't be ashamed. I'm going to stand up for you. I'm going to stand with you. I'm going to have your back. And each and every one of you deserves to be proud, and you deserve dignity. And that was Harvey Milk, and he ran for the city supervisor in San Francisco, was elected, and then was assassinated along with the mayor by a guy who'd had too much junk food. So that sparked the riots of 1979 in San Francisco, when it was announced that the guy who had murdered Harvey Milk and Mayor Moscone was guilty of involuntary manslaughter because he'd had too many Twinkies. And his sentence was 6.5 years, and he ended up only serving 5. So, and interestingly, several years ago, I was in San Francisco, and I went down into the Castro one evening, which is the gay district in San Francisco, and I was talking to a guy who's from Oklahoma, and he was almost crying, and he said to me, you know, I got beaten up, and my family kicked me out. I was in Oklahoma, I didn't know where to go, and so I just started heading west. I ended up in San Francisco, and Harvey Milk was my Martin Luther King, because it was the first time somebody had told me that I could be proud, and that I didn't need, and I shouldn't need, to be afraid. So that's why I wanted you to know about Harvey Milk and the 1979 riots in San Francisco. I also wanted you to know that my community has an anthem, and that anthem is Somewhere Over the Rainbow. And that actually comes from the AIDS epidemic, because we lost an entire generation of men, and this is always sung at our funerals. And unfortunately, we became really, really good at putting on funerals at a certain period of time during the AIDS epidemic, but this is our anthem. And my community does, in fact, have an anthem, and that's probably something you didn't know either. And also, our use of the term family means something a little bit different, because family is code for, are you gay? So, if you say, is he family? Well, then somebody can say, yeah, he is, or no, he's not. He may seem like he's family, but he's not. Or, he's not family, but he's cool, he's okay. So, and then you can say something like, you know, it's okay to be yourself around her because she's family. Or it will be all right because this person has family, which means that they are related to someone gay. I'm just giving you all this great code language that you now will know. You can run around and ask people if they're family. Oh, you can't see that. That's Friends of Dorothy. I'm sorry, that didn't come out very well. Friends of Dorothy is another term for a gay man. And so, and that has to do with the whole Wizard of Oz thing, but Friends of Dorothy is actually the government became so wound up over the whole Friends of Dorothy thing that they thought there was someone in Chicago named Dorothy who could out all of the gay service members in the state of Illinois. And so they actually put a whole bunch of money into trying to find Dorothy. That's a true story. Of course, he never did. And I just wanted to talk about some of the people that that you may or may not know about. Now, I'm having trouble keeping up with this also because, I mean, people are coming out of the, I mean, I get up, you know, once a week and someone new has come out of the closet and I'm like, wow, you know, you gotta be kidding. But anyway, Greg Louganis, gold medal winner. I'm proud of the fact that people in my community, no matter what has or hasn't happened to us, I mean, we will put on the red, white, and blue and be so proud to go to the Olympics. We will put on any service uniform and go to battle for our country. And I think that's important to keep in mind. So here's Greg Louganis. I have met him, and he's the most gracious individual in the world. But anyway, roundly considered the best diver. Now, I'm putting this up because we're taught, of course, that we can't teach homosexuality in the schools. But I think it's kind of important to know that Walt Whitman was writing his love poems to another man. I mean, I really think that that puts it in an interesting perspective. And a lot of people don't know that Walt Whitman was gay. And that's just an example. There are many, many in history. Michelangelo, oh, damn, I don't think that we ought to be talking about, you know, Michelangelo in anything other than just the strict sense of the term. But, I mean, come on, we wouldn't have some of the greatest art in the world without Michelangelo. Michelangelo was an openly gay man way back when. I mean, my God, he did the Sistine Chapel. That's decorating, people. That's really knowing how to decorate, okay? That's where it started. You know, we're told that gay men are sissies. This guy was an NFL defensive tackle for 9 years. Came out after he got out of the league because he was afraid someone would, you know, really do him physical harm if he came out while he was in the league. But he's a great guy. Of course, Martina. Now, the interesting thing about Navratilova is she had to come out because she was asked directly when she was applying for citizenship in this country if she was gay. And so she had to be truthful. And so she got outed in that fashion, and she lost millions and millions and millions and millions of dollars in endorsements. All of her endorsements were pulled, and they were pulled right then and there because she answered a question truthfully under oath. Anderson. I mean, he's just been in the last, month? It's like, thanks, Anderson. It's not like nobody knew, but thank you for... Thank you for acknowledging that. Well, I don't know what took you so long, but whatever. Another television personality, Rachel Maddow. The one NBA star who has come out. Of course, he came out after he was out of the league. This is what we call a tall gay person, okay? Shelley Wright, the first country and western artist to come out, and she came out about 2 years ago and has been totally frozen out of Nashville ever since. And she has an interesting story about why she came out. She accepted her own sexual orientation, but living a double life and living in the closet was driving her just almost to her death, and she found herself kneeling in her living room with a gun in her mouth, ready to commit suicide. And she put the gun down and said, okay, that's it, I have to come out, I can't stand this anymore. Oh, I'm sorry. Excuse me, but I'm going to read this for you because I'm sorry that you can't see it, but I think it's kind of important. This is Fred Phelps' website, and it's called www.godhatesfags.com. And he's very, very proud of this particular quote. And it's disgusting, but I'm going to read it to you because I think It helps put in perspective some of the things that my community goes through. Filthy sodomites crave legitimacy as dogs eating their own vomit and sows wallowing in their own feces crave unconditional love. And this is the kind of hate that he spews on www.godhatesfags.com. Well, back at you, Freddie boy. Back at you. And these are a couple of gentlemen who decided to help Fred Phelps. He goes around the country doing this. I mean, I don't know, the guy, I mean, it's like, get a hobby, dude. I mean, this is really, really not, but he does this over and over again, and it's really disgusting. And he has come to Seattle, and he has come to funerals that I have attended, and it's very, very sad to be burying someone that you love and to walk out and see this crap. This is someone else who decided to help Fred. And this is Greta Kammermeyer, and the reason I bring her up is that most people know the story of Greta, and she lives up on Whidbey Island, and her mother's ill for many, many years, and finally passed away. And so Phelps came out and came to her mother's funeral and did this, and then told her that and her partner has an illness, that when her partner dies, that he's watching, and when her partner dies, he will be back. And he will do this again at her funeral. And the reason that I find this interesting is that then Phelps went too far, because he did this at straight people's funerals. And that's when everybody got wound up. And that's a little bit difficult for me, because we've been putting up with this crap for years. And we came up, my community, because the police aren't going to help us, et cetera, we came up to this thing called angels. And we have people stand with these big, big wings on and block Phelps. Who'd have thunk? Sally, if we'd only known. Now, think about this. She has been, that's her partner, and they've been together for 27 years. And we all know who Sally Ride was. Her partner will not get a dime in any federal pension after 27 years together, because DOMA doesn't allow it. Our icons. And one of the reasons I'm telling you all this is that as gay people, we kind of get erased from history. We don't want to talk about, who did the Sistine Chapel? But Melissa Etheridge has written a really, really interesting song about one of the plane that went down in Pennsylvania on 911. The passengers who took over that plane, the one who led that charge was a gay man. And that people either didn't know that or it's been forgotten. And she wrote a song called Tuesday Morning, and you can look up the lyrics, it's very interesting, but it says, you cannot change this, you can't erase this, you can't pretend this is not a truth. Can you live with yourself in the land of the free and see him as less of a hero than the other three, when it might begin to change you in a field in Pennsylvania? I thought that was pretty powerful, because we get erased so much. Charlene Strong from Seattle. It's very, very important in healthcare. She's living in Seattle. Her partner, they have this horrible flood at their house. Her partner's basically drowns at home. They rush her to the hospital. She's still alive. They've been together for 14 years, and they won't let Charlene Strong in the emergency room in Seattle to see her, because they said, well, you're not family. Obviously, they didn't know the real definition of the term family, but that's how some of our laws got changed, and that's very, very, very important in my community, and it's a very, very huge deal. Ed and Jamie, they're down in Olympia fighting for us all the time. And, hey, we're here, we're queer, and we're not going anywhere. So I just have one more thing. I know we're running out of time, but if we could load that next thing. The weird thing, and I guess it's not weird, but what's very, very different about my community is that we get kicked out of our families, okay? And other minority groups, that doesn't happen. And in my community, you don't say, you know, how's your family? What's the deal with your family? It's, do you have a family? And that is code for whether or not your family has disowned you or not. But, you know, come on, get to know us, because we're good people and we're funny people and we've gotten by on our wits. So with that, I'm going to end this with something I think you'll enjoy.
It's being black. It is, because there's some things that I had.
It really help doing stand-up if we have the audio. Can we back that up? Okay. This is Wanda Sykes talking about coming out to her parents as black.
That I had to do as gay that I didn't have to do as black. I didn't have to sit my parents down and tell them about my blackness.
Is that working?
It's harder being gay than it is being black. It is, because there's some things that I had. There's some things that I had to do as gay that I didn't have to do as black. I didn't have to come out black. I didn't have to sit my parents down and tell them about my blackness. I didn't have to sit them down. Mom, Dad, I gotta tell y'all something. I hope you still love me. I'm just gonna say it. Mom, Dad, I'm black. Wait, what did she just say? Oh, Lord Jesus, she didn't say black, Lord. Did she say black? Mom, I'm black. Oh, no, Lord Jesus, that's black, Lord. Oh, that's black, Lord. Anything but black, Jesus. Give her cancer, Lord. Give her cancer. Anything but black, Lord. It's like, Mom, yeah, I'm black. That's just how it is. No, you know what? You've been hanging around black people. You've been hanging around black people, and they got you thinking you black. They twisted your mind. It's like, no, Mom, I'm black. That's just how it is. What did I do? What did I do? I knew I shouldn't have let you watch Soul Train. Was it Soul Train? No, Mom, it wasn't Soul Train, Mom. It's just who I am. I was just born black. Oh, you weren't born black. I don't want to hear that. You weren't born black. The Bible says Adam and Eve, not Adam and Mary J. Blige.
Thank you very much.
Thank you, Lori. Thank you for being authentic and for sharing, because it is important that we have cultural competency, which also raises an interesting point when it comes to dealing with bullying, because it can be even more difficult. So we definitely want to honor our question and answer session and open that back up. I'm sure Lori would be happy to answer any questions, and we've got Chach here as well.
Yeah, I just wanted to comment on some of the surveys that people filled out, and it was interesting on the first question, if you've ever been bullied by another lawyer or party. Of 19 people that responded, 15 said no, 4 said yes. No, have you ever bullied another lawyer? I'm sorry, that was backwards. Have you ever bullied another lawyer? 15 said no. Have you or your client ever been bullied by another lawyer? 15 said yes. So that was very interesting, and that brings up an interesting point for me, because I actually think while it's easy sometimes to recognize bullying in other people, particularly if it's on its face bullying, it's also the passive-aggressive bullying that people don't talk about as much. And then would you actually recognize it in yourself? Would you know when you're being a bully? Because you just might see it as, you know, that's either the way you handle things, or a person might just react to something that you do in a way that you think, wow, are you being sensitive? I don't think of myself as a bully. So would attorneys actually, and all people, recognize it in themselves? So that's something I'd like to hear. You know, where's the line? Do people think they would know when they've crossed the line or not? And then what do people think about, not the bullying that's on its face, but the passive aggressive bullying, where when do you know that the line has been crossed? Does anybody have any comments on that? Do you guys have any comments on that?
I sometimes do it in response to opposing counsel bullying, but I always warn my deponent, my client, that it's coming, because, you know, it can be pretty frightening if you're sitting there and all of a sudden, you know, your strong but lovely, charming counsel is all of a sudden going tooth and nail at the opposing counsel. So I sometimes resort to that. If I've got an aggressive bully on the other side, I stand up in between me and my client and take it and give as good as I get, as my client gets. But always I've prepared my client for that so that they don't freak out.
I just want to ask a question. Just describe what your behavior is that you define as bullying in a deposition.
Counterbullying. Counterbullying. You know, well, if shouting, you know, standing up, pointing at him, sorry, guys, it's always a guy. Saying, you know, you sit down and stop that behavior right now or we're leaving. And I sometimes go to packing up my suitcase, my briefcase, and walking out the door. You know, it really depends on the situation. Most people who have dealt with me before, this is not a problem with, but sometimes I get, you know, excuse me, younger lawyers, a young buck who decides, you know, the old broad across the table is a pushover, and, you know, they try to be jerks, and I jerk right back.
That's a good question. I understand counterbullying is what you were talking about, but I thought that I was going to get challenged most on the question of, doesn't bullying work as a pattern for plaintiffs against adjusters in particular, and to some degree insurance defense counsel? Because I think there's a legitimate case to be made that it does work. If you are a pain in the neck from the word go all the way through, there's just going to naturally be a motivation on the other side to just throw a little more money at it to make Sims go away, right? And, you know, and people might do that anyway with me, that was something that I thought would come up here, and I just want to hear people's thoughts. I don't mean to interrupt. I know you have other questions, but you know, that's the other side of the coin. Is bullying an effective tactic that we should be employing? I mean, I have my personal opinions on it, and I think that's that sort of zealously thing that I started off with, that is beyond, but I put it out there.
Judith, my personal opinion is that as a woman, you are more apt to be in a situation where you have to draw your line in the sand. I don't know if you feel that way, but I definitely have moments in time with some counsel, and I'm not going to try to outshout anybody. I'm going to try to do it as professionally as possible, but you know, if you don't draw your line in the sand, then eventually you are doing your client a disservice.
Got another question here.
My question is kind of the flip side of what you asked. How do you handle when opposing counsel uses the accusation of bullying as a sword? I was in a deposition recently where my client, who was a very large man with a bald head, was accused of intimidating a witness. I know for a fact that he was not intimidating the witness, and he voluntarily removed himself from the deposition, which put me at a disadvantage because he couldn't then comment and guide me in the deposition of this witness. And I was unsure of how to handle that, other than to try and establish a record that there was no intimidation. But I wonder how, if anyone else has had that kind of experience and how you handle it.
Panel?
Well, it happens to me in every case, and so, no, I'm just kidding. Offhand, I think you could just make a fair record, and, you know, I even think in some instances, even if you know you're being falsely accused, go on the record and say, oh my goodness, I'm sorry, well, what I can't do to, you know, accommodate you, and, you know, at the end of the day, you end up in front of a judge, and if you look, you know, pleasant, and even, you know, like how bad can it be? While I have the microphone, I'm going to dare to take liberty with the agenda a little bit and say, I think there's a form of bullying that I would describe bullying that I don't think we've talked about that comes up a lot, and that's in the context of you're sitting on one side of the table, somebody else is on the other, and they explain to you how right they are by virtue of how many years that they've been practicing. And that makes them inherently right, better, stronger. And I'm curious just to hear if anybody has any particular well, if any of the senior lawyers who never do that have any thoughts on that, or any of the younger lawyers, or whoever has coping mechanisms for that situation, because, you know, even though I feel like I'm getting older, I feel like it comes up all the time. So I'm curious to hear coping mechanisms with that form of bullying.
And that came up in the questionnaires too.
Yeah.
I'm working on a case with a younger lawyer. He's about 1 year out of law school. And he's handled that really beautifully, because when opposing counsel says things like they've been practicing law all these years, and he says, well, I haven't been practicing law all these years. I've just been practicing law for about 1 year, but from what I know, from what I've learned in law school, and then he just, as you say, makes his record. He states factually what's been going on. And this younger lawyer actually, in a recent CR 26I phone call, he taught me that what we call a Rule 37 call is now a 26I call, by the way. When you confer with opposing counsel about, in this case, it was garbage work product claims that they had. And I got emotional, and he's the one who helped calm me down. And we focused on the law, we made our record, we went to court. Actually, he went to court, I came to Suncadia. And with our record and with putting it together, he got the ruling on Friday that no, indeed, this stuff that they're saying is work product isn't. And that brings me to a point that I wanted to make earlier, which is when we have these situations of garbage objections or garbage claims and bullying activity by the other side, I find it very helpful to think about when this goes to the judge. Is the judge going to say, I don't care about you lawyers, you're just, you know, doing this to each other and I'm not going to give any relief? Or looking at it from the point of judge's view, do you have a compelling argument? In this case, this younger lawyer and I have twice been in front of Judge McPhee, and both times we've gotten the rulings that we've wanted because of putting the record together and thinking about, are we right on the law or not?
Lincoln, you and I have both seen, when we were in the Air Force, you see this thing where sometimes the guys who went to the academy all slam their ring down on the table. And it's just
I was enlisted, so.
no, I was too. I was a sergeant, but you see them do it. The academy guys want to show that they're
Oh, yeah.
better than everybody
Yeah.
else because they slam their ring down. And among attorneys, you see it on the listserv sometimes. There's sort of a battle of who's got the lowest bar number. When I'd practiced about 6 years, I was lead counsel on multi-state antitrust prosecution against all the oil companies for price fixing, which took 18 years, but we finally won.
People can't.
We took 18 years on that case, we finally won. I was taking a deposition of the CEO of Shell Oil, and he was defended by Bill Simon from Howard and Simon. And he objected to one of my questions, and he said, I object. He said, did you ever take evidence? For that matter, did you ever go to law school? And I just asked the reporter to mark it, and I said, okay, just ask the witness to answer the question. He said, no, answer my objection. I said, tell your witness to answer the question. He didn't. I went and I made a motion to the judge, and after that, Bill Simon was fine. He'd still make stupid comments during the depositions, but then we'd go have a drink afterwards. So I think you just don't respond in kind to him. You just, as everybody says, make your record, do what you need to do for your case, and it doesn't matter how big or important they think they are, how low their bar number is. They're no different than you or I.
Someone had.
Okay, I have to come out and admit that sometimes I get a little uncomfortable when I hear the term bullying batted around. Because I think sometimes, and I've witnessed oftentimes, in the school setting, often this comes up. I'm a parent of 2 children. One is age 7 and one is age 9, so they've had a few years now, kindergarten through 3rd grade now, to have some experiences. I think that bullying can sometimes be a term or a label that's used when we're talking about something else. We're maybe talking about a category, that's a lesser included category, maybe like unprofessional conduct. And when, Judith, you were describing your circumstance in your deposition, when you responded, and maybe you responded in kind and you kind of told us what you did, I didn't think that sounded like bullying to me. It sounded like perhaps it crossed your line of what you might consider professional conduct, and I'm not sure. But to me, bullying is a pattern of conduct, physical or mental or emotional, that's done perhaps with a concerted effort to oppress or to keep down or to hurt and to harm. But it's something that's demonstrably different sometimes than just poor conduct on the playground or a bad actor who needs to be talked to and reformed. And in circumstances, and I'll have to draw back to the analogy, Sims, I appreciated that you brought that up, the school context, because I think that's often where we do hear this come up. Many of us are parents or grandparents, and we do see it. But I've seen so many mistaken labels cast out as bullying, even one toward my son once, and he came home and said, I'm a bully. And I said, well, tell me what happened. And he described something, and I won't go into great detail, but he described something that, well, first of all, I already know my son's not a bully, and I know him pretty well, but he described something where he was actually responding in defense of someone else. And he was caught, often you don't see the first act, you see the second act. Someone came and said, well, you're bullying, you need to come to the principal. And principal said, why were you bullying? So he's coming home thinking, I'm what everyone else is casting out as a terrible person. And he felt labeled, and I felt he was labeled. And I think sometimes we make a mistake, and we may do that even in this profession and when we talk about it. So I only say this because I guess I want to caution us to make sure we're identifying what we're talking about and not making it something that it isn't.
Any comments from the panel regarding that?
I completely agree. I think persistence is a key piece of the bullying. That it's a pattern of behavior, not a one-off. And it's a lot easier. I mean, you try and want to ignore the first couple and then engage if it's happening to you.
Got another question here.
I don't know if I have a question. I've got an experience of practicing in a county where we had a prosecutor who was notorious for bullying. And the reason that people did it he did it is because it worked. He intimidated judges, he intimidated defense counsel. It was it was something that finally became quite an issue even in the campaign where, he lost an election by an astounding vote margin. And I think eventually everybody became aware of the fact and he was found out for who he was. One of the probably everybody's most notorious examples of bullying, I think, was Senator McCarthy. If you remember that hearing where he was accusing the Army of being infiltrated by communists, and then I can't remember that lawyer from Boston who said to McCarthy after he accused one of his associates of being a communist, "Have you no decency, sir?" And from that moment on, McCarthy was history. He didn't have any of the credibility. He didn't have any of the authority of his office. And I think you just have to overcome bullying with taking the high road. And if you have that in a deposition, the first thing you're going to do is suspend the deposition and go to the court. I don't think I don't think it's helpful to really engage in that kind of counter-bullying activity. You just end it.
Thank you, and we've got another comment over here.
Yeah, this will be the last comment.
Thank you. I'd like to talk about something that was mentioned at the beginning of the presentation today, and that is the relationship between attorneys and client allegations of bullying. I'm an Oregon lawyer, and I see we have a representative from the Washington bar here. And I'd like to know if you've seen an increase in clients claiming that their attorneys are bullying them. And the context I will give you is I tend to represent people in employment cases. People are on very desperate times. As lawyers, we file lawsuits and we have big prayers that we're seeking in the lawsuit. And then as we get into litigation, we find out the clients have real and objective problems with their cases. And we say, I know we put $600,000 in the prayer, but I think we can settle this case for $125,000. You've admitted in your deposition that you didn't perform all the essential functions of your job. I think that they probably will be able to convince a court that they had a legitimate reason for terminating you and not due to your protected class. You follow the standard procedure of notifying the client of all offers that have been made and put in writing the problems with their case, and the client says, "You're bullying me." Any suggestions?
Well, I don't know if I could speak to how many people are actually, turning in discipline actions against their attorneys. I do know that it tends to go, I think the solo practitioners receive a little bit more than, say, the big firms where clients are upset. Isn't it shocking? But I do know that when clients get upset, they are feeling like their attorney wasn't doing the right job and what have you. I honestly can't probably give you great advice on that. We don't have a specific RPC that does state anything about bullying. I think the key is just being able to explain to your client that this is what we're arguing, this is what we can show, and this is what you're actually going to be able to get. The reality is the client is going to respond how the client can or wants to, and all you can do is make your record and explain it fully to them.
Document.
I think we've had a very healthy discussion here today. I think it's very important to sort of look into yourselves and think about, like Liz was saying, is this really bullying, or is this being aggressive, or is this being an advocate? It can take many different forms. I think people typically know when someone's, if someone's making a snide remark, that's a personal attack. Obviously, that's not just being an aggressive advocate for your client. That's something different. And if it's a pattern in practice, it's bullying. And just recognize it and document it and do the best that you can to protect your clients. But also, think about, practicing with some civility as well. there's nothing wrong with that, and I think we've had a healthy debate. I think we've had a great panel here. I'd like to again thank Lincoln, Lori, Chach, and Sims for the great presentation that they've had here today. And on behalf of myself and Celia and the WSAJ Diversity Committee, we are very pleased to have this great attendance at such an early hour in the morning on a Sunday. And it's a beautiful day. Enjoy the rest of it and safe travels back to wherever you've come from. Thank you.